Mr. Chair, is the MLA on?
Yeah, we're going to go live here in 1 minute.
Okay, thank you. Before it goes live, welcome, Mr. Isaacs. I've heard a lot about you. I'm excited to hear the presentation today.
I will call this meeting of the Special Committee on Reconciliation and Indigenous Affairs for April 8th, 2021 to order. The first item on all of our committee agendas is to be led in prayer. MLA Marcellos, can you do us the gesture of leading us in a prayer?
Thank you, Mr. Chair. May the sun bring you new energy by day. May the moon softly restore you by night. May the rain wash away your worries. May the breeze blow new strength into your being. May you walk gently through the world and know its beauty all the days of your life. Amen.
Amen. Thank you for that, MLA Marcellos. So today's agenda has a presentation on implementation of the United Nations Declaration on Rights of Indigenous People with Mr. Tomic Isaac. Can I get a member to move the agenda? MLA Wozniak, motion moved. I will begin today's meeting by allowing all MLAs to introduce themselves, both those who are in the meeting room with us today practicing social distancing and those online. This also helps as a bit of a mic check exercise for all of us. So I will begin with those on the phone, starting with you, MLA Marcellos, and then I'll go MLA Semler and MLA Simpson and Madam Premier. Go ahead.
MLA Marcellos, MLA for Tabacha.
Hi, I'm actually the chair, just having technical difficulties this morning with my Wi-Fi, so Rylan will be chairing this meeting. My name is Lisa Semler, and I'm the MLA for Nuvik Twin Lakes.
Good afternoon, if you can hear me. I'm Carolyn Cochran, Premier of the Northwest Territories. I'm the MLA for Range Lake and Yellowknife. Thank you.
Good afternoon. Can anyone hear me?
Yes, we can hear you, MLA Simpson.
Thank you. I'm RJ Simpson, MLA for Hay River North, Minister of Education, Culture and Employment, Minister of Justice and Government House Leader. Thank you.
Thank you. I will now go to the introduction, starting on my left here in the room.
Kevin O'Reilly, Frame Lake.
Good afternoon. Carolyn Wozniak, MLA for Yellowknife South, Minister of Finance, Minister of ITI, and Minister responsible for the status of women. Thank you.
Thank you, Evan, for the introductions, and it appears mics are working just fine. Next item on the agenda is declarations of conflict of interests. I will take those as and when from committee members, or hearing none now. With that, just so everyone is aware, we will aim to have this be about a 1-hour presentation. Mr. Isaac, I'll turn it over to you to present, and then we'll allow MLAs to have any questions or comments. I feel like there's many ways to introduce you, Mr. Isaac. You were at one point an ADM for our government who helped establish Nunavut. You, in the previous assembly, wrote a special report on a path to reconciliation in the Acacho land claim process. You have written many books, I believe about 15 books, and your book on Aboriginal law is, it's the staple of many lawyers in law school. I've read it myself, so I'm truly excited to have you here today. You are an expert in the field, and I thank you for all the work you have done. And with that, I will pass it over to you to begin your presentation.
Thank you, Mr. Chair, and thank you, committee members. I hope you can hear me okay. And thank you for that gracious introduction. So I'm really honored to be here with you today. I have a particular fondness for the Northwest Territories, having spent a number of years of my life living in and working, living in Yellowknife and working in the Northwest Territories, and continue to work in the Northwest Territories today. So it's an honor to be here with all of you. The presentation that I've put together for the special committee, if you go to the next slide, I'll give you a couple of very brief introductory remarks, and then really to understand the context of UNDRIP in a Canadian legal and public policy perspective, we really need to understand the history of UNDRIP, what's in it, and I will talk about a couple of recent examples of implementing UNDRIP in Canada, and then I'll give you a few concluding remarks of, I think, some of the positive elements of UNDRIP to Canadian society, and also some of the challenges from a strictly legal and public policy perspective. So with that, if we could go to the next slide, please. So by way of introductory remarks, as I said, thank you for the opportunity to present to you today. I'm sure I don't have to tell any of you that our country is in the midst of significant developments in respect of Indigenous peoples, and has been for many decades, dealing with Indigenous rights and the country's ongoing efforts towards real and lasting reconciliation. We know that this is a work in progress. Reconciliation is a critical component of our country's ability to reach its full potential in respect of its relationship with Indigenous peoples and the protection of Indigenous rights. My presentation this afternoon is intended to assist you, the special committee, in your discussions and deliberations regarding the implementation of UNDRIP and what it means for the Northwest Territories. I want to be very clear before I start. I'm sure, again, I don't have to tell any of you that this area, generally this area, is ripe with a lot of politics. I should tell you I'm nonpartisan. I'm here today to give you what I've attempted to be my best kick at objective comments around UNDRIP. My comments are not intended to represent any opposition to UNDRIP, and I want to be very clear about that. UNDRIP is a powerful and positive instrument for the protection of Indigenous rights internationally. Rather, my comments and the critiques you'll hear today are actually intended to promote and to advance Canada, the provinces, and of course the territories towards real and lasting reconciliation. And key to reconciliation is the concept of truth. And so what I want to do is present to you some facts and hopefully encourage a dialogue that will be as frank and as transparent as possible. I have a very strong view as a practicing lawyer that speaking frankly and honestly about these issues, in fact, is the best way to achieve reconciliation. And so it's in that spirit that I come before you today. So with that, if we could turn to the next slide around the history of UNDRIP. And I'll talk first about the drafting. So the next slide, please. UNDRIP is an international and very frequently referred to as an aspirational document that was designed to be a global benchmark for Indigenous rights. And it was the result of over 20 years of work by the Working Group on Indigenous Populations, the international community, Indigenous leaders and experts, and of course many Canadian Indigenous leaders and Indigenous peoples advocates globally. The drafting of UNDRIP was marked by several impasses, and particularly with respect to provisions regarding self-determination, lands, territories, resources. I'm going to take you to a couple of those provisions a little bit later. And the principle of obtaining the free, prior, and informed consent You'll hear me refer to the acronym as FPIC, by Indigenous peoples for decisions that may affect them, and other provisions that may impact national and territorial integrity. The next slide, please. So, on September 13th, 2007, UNDRIP was adopted by the United Nations General Assembly. Now, let me stop here. There is a general view, and you'll hear this in the popular media, that somehow UNDRIP has now become part of the international standard. And again, my comment here isn't to be against UNDRIP, but it's to get the facts out. When UNDRIP was adopted, according to the United Nations at that time in 2007, there were 88 states that actually had Indigenous peoples. Of the 88, only 42 voted in favor of UNDRIP, which really underscores the need for UNDRIP. I want to be very clear. This is exactly why UNDRIP was so needed, is that you've got many states in denial about Aboriginal and treaty rights or Indigenous rights more generally. But only 42 states voted in favor, so less than a majority of those states actually with Indigenous peoples. And of those that voted in favor, many of them actually put the same caveats on their vote that I'll get to in a moment that Canada ultimately did. That is subject to their internal constitutions and internal laws. So again, the notion that Canada is somehow out of sync with this majority that actually have Indigenous peoples, I think, is questionable. 4 states at the time voted against UNDRIP: Australia, Canada, New Zealand, and the United States. Canada's concerns were that it, in my view, this is my summary, wanted to sign on to UNDRIP, but was concerned that would run afoul of existing Canadian law, which I'll get to in a moment. Now, you might ask, well, what about the other 42 states that actually had Indigenous peoples at the time? They either abstained or didn't bother to show up at the United Nations that day to vote. Of those that abstained, 100% had Indigenous peoples. Of those that didn't bother to show up to the UN that day, 93% had Indigenous peoples. Now, my point in raising this is, again, to provide a factual backdrop to where UNDRIP sits in the international order. The next slide, please. Canada, as I already noted, initially voted against the adoption of both the draft and the final versions of UNDRIP before the Human Rights Council and the UN General Assembly. Canada's initial votes against the adoption of UNDRIP, certainly in Canada's view, did not represent a refusal to protect Indigenous rights domestically. And that is a factually correct statement. All one needs to do is look at the existing body of Canadian law. And so I'll get to that, and again, in a moment. I'm going to talk about where Canada fits as a country in terms of our Aboriginal treaty rights development from a legal perspective. Instead, Canada's position was that UNDRIP contained provisions that were overly broad, very general, and again, I'll take you to a few of them just again to give you a sense of some of the challenges of saying one is going to completely implement all aspects of UNDRIP, and fundamentally are incompatible with Canada's legal regime that constitutionally protects Aboriginal treaty rights against unilateral state action. So I'll come back to those points in a moment. If we could turn to the next slide, please. In November of 2010, Canada endorsed UNDRIP, quote, as an aspirational and non-legally binding document. Of course, as I'm sure many of you know, in 2015, the critically important Truth and Reconciliation Commission of Canada issued 94 calls to action, including those that called for the implementation of UNDRIP domestically. I will note that that call to action was absolute, in the sense it was the implementation of all of UNDRIP. And I'll stop there to say that this is really the issue. For those of us, and I believe it's the vast majority of people working in this area, know that this is a very complex area. This isn't an area of black and white. Certainly Canadian law has developed with a lot of nuances in this area. And so when looking at sort of an absolute adoption of anything into an already existing legal regime, it certainly raises fundamental questions of, is it possible? And again, I will be coming to that later in my presentation. And then in May 2016, Canada endorsed UNDRIP. Now, the official line was without qualification, but of course it was with qualification. So even though it was said it was without qualification, it in fact, that qualification was very similar to the previous endorsement in 2010. And that is to say, Canada committed to adopting and implementing UNDRIP, but in accordance with the Constitution of Canada, i.e. in accordance with existing Canadian constitutional law. So that's a really important point. And again, it, I think, draws a focus on the difference between what a public statement might be, for example, saying without qualification, when in fact there is a material qualification on the endorsement. And this is a matter of fact. It's not open for debate. That Canada's unqualified endorsement is of course qualified by, as it should be, by our existing Constitution of Canada, which of course includes Section 35, which protects existing Aboriginal and treaty rights. So with that, if we could move to the next slide, please. The content of UNDRIP. So if you go to the next slide, please. Before I jump into UNDRIP, I'm going to give you a very brief summary of an overview of Canada's legal regime as it applies to the protection of existing Aboriginal and treaty rights in Canada. I want to be very clear. Internationally, Canada is the leading protector of Indigenous rights domestically against unilateral state action. I want to also be very clear that I'm not an apologist for our country. We are not done this amazing road that we are on. I visit so many communities that continue to suffer severe health, education, social trauma, and broader social issues, and clean drinking water, the lack of clean drinking water, lack of economic opportunities, and gray areas in our protection of rights. But when you examine Canada as against other nation states around the globe with Indigenous peoples, there is no question that Canada is unique and stands alone in the constitutional protection of these rights against unilateral state action. Now again, I want to be clear. That doesn't mean that there aren't people in Canada who say we can do better and we need to do more. My comments to the committee today are in no way to suggest that those folks, I want to be clear, I actually act for some of those folks in parts of Canada, that Canada needs to be doing a better job at protecting Indigenous rights. But my point is that when you look at other states around the globe, we are unique. And that is in large part thanks to the efforts of our own Indigenous peoples in this country, First Nations, Inuit, and Métis, after long-fought battles against governments trying to restrict their rights. But it's important to start with the truth. So there is this notion that somehow Canada is lagging behind the rest of the world. And it is simply not true. We actually lead the world. And there is possible we are open for debate whether we are number 1, 2, or 3. I would argue we are number 1. My point isn't whether I'm right at number 1. My point is there's no debate that we are among the world's leaders on protecting Indigenous rights at law. This is before you get to UNDRIP. Thanks to the efforts of Indigenous leaders, their lawyers, and Canadian courts that took a purposive approach to understanding what Section 35 meant. Remember, public governments were of the view that when 35 was put into the Constitution in 1982, it was intended to be what? An empty box. It was meant to appease the First Nations, the broader Indigenous lobby. And it was our courts and Canada's Constitution and the efforts of our own Indigenous people that ultimately landed on the single most sophisticated legal regime on the planet today to protect Indigenous rights. And again, I'm not suggesting it's perfect, quite the contrary. I am not suggesting that we don't have a long way to go. But I think my point is clear. And just to give you an example, Section 35 is, of course, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. One sentence in Section 35.1. We have over 70, it's almost 80 decisions on that one sentence since 1990. That's more than 2 decisions a year from the highest court of our country. And I think I've already been clear about Canada's robust system relative to other states. Although not perfect, Canada is on its way to real and lasting reconciliation. I don't want to sugarcoat this. I know that there are many Indigenous peoples both on the committee and observing this today. We have a lot of work to do in Canada. And my comment, again, I want to stress this, is not to be an apologist for where we are today as a country. What I am trying to do is speak factually and objectively of where Canada sits vis-a-vis the rest of other nation states on the planet, given that we are talking today about an international document. And to date, no country has implemented UNDRIP as a whole. I sometimes use the example of even Bolivia, which has, I believe, it's 91% of Indigenous peoples. Even they stripped out the FPIC provisions of UNDRIP. Anyway, the next slide, please. So let's talk a little bit about UNDRIP itself, what it is. UNDRIP, we know, serves as a guide and as a benchmark, and I will say a very important benchmark for a country's human rights performance in respect of Indigenous peoples. But this is an important point. For those of you who have not looked at UNDRIP, understand that it contains 24 preambular statements, 46 articles, and together, the 46 articles, not including the preambular statements, the 46 articles add up to 74 distinct paragraphs. That's almost 100 different paragraphs in UNDRIP. This is important because later I'm going to take you to legislation and proposed legislation that says every law in a province must be consistent with UNDRIP, which would mean it would have to be consistent with the 24 preambular statements and all 74 distinct paragraphs of UNDRIP. And you will hear later from me that that is impossible. That cannot be done. And that presents a real challenge to the rhetoric in this area. So, UNDRIP delineates individual and collective rights for Indigenous peoples. And again, some of them are so important, talking about the protection of culture, language, health, education rights, the things that Canadian law right now doesn't deal with. And these are the things that I believe UNDRIP can be a real lesson for Canada. The very things we need to make progress on, which is improving the well-being of our first citizens, our first peoples. The next slide, please. So let me take you to one example. And we'll come back to some of these a little bit later when I take you to some of the legislation. But Article 26, Indigenous peoples have the right to the lands, territories, and resources, now here's the important part, which they have traditionally owned, occupied, otherwise used, or acquired. I'm going to suggest to you that that is all of Canada, or most of Canada, the vast majority of our country. Article 26, there are no caveats on Article 26. It's very clear on its face. There is a right to those lands, territories, and resources. This directly contradicts existing case law around Aboriginal title. So when a government says, we are going to ensure that every law abides by UNDRIP, I would like to ask you to give this a thought. This is one article. How would you align all of your laws, and by the way, that includes regulations, to ensure that Indigenous peoples' rights to, and I'm not questioning whether Indigenous peoples had those rights, but to implement a traditional right to lands that were once occupied, owned, used, or acquired, and that they have a right to those lands. I believe my point is rhetorical in nature, because I think we all know that that on its face is an impossibility. The next one, Indigenous peoples have the right to own, use, develop, and control the lands. And again, for the modern treaties that have been settled, we understand these concepts. Many of these concepts are embodied in our modern treaties. And again, I don't have to tell anybody sitting around the table or virtually sitting around the table, you are expert on these things. But that they possess by reason of traditional ownership or other traditional occupation or use. So what does that mean for the modern treaties? What does it mean for the treaties that have been settled elsewhere in Canada? If that clause is to mean something, it means that we're going to have to fundamentally challenge the fundamental starting point of Canada and our existing legal regime. And then it goes on. States shall give legal recognition and protection to these lands, territories, and resources. So which ones? The ones that were traditionally owned, occupied, or otherwise used or acquired. So that means all the land. So what will that look like? Will it be meaningful? If we are serious about reconciliation, I will say this: it must be meaningful if we are to respect what reconciliation is all about. And shall be conducted with due respect to the customs, which is appropriate, traditions, and land tenure systems of the Indigenous peoples concerned, not the state. The next slide, please. Article 28. Indigenous peoples shall have the right to redress by means that can include restitution. And when this is not possible, just, fair, and equitable compensation. And again, things that were done to the land without their free, prior, and informed consent. I want to be very clear. We understand the importance of these kinds of statements, but I'm going to take you to legislation that says all laws must be consistent with UNDRIP. And I'm going to suggest to you that's impossible, looking at Article 26 and looking at Article 28. Next slide, please. Now, here's some articles. I've mentioned the ones, I'm not going through the ones on health, the protection of oral traditions, of languages. There is so much good in UNDRIP that I think Canada could focus on as a country. But here are some other ones that I think are really important. Indigenous people shall not be forcibly removed from their lands or territories. No relocation can take place without the free, prior, informed consent. I think most people would agree with that. I'm just giving you a suggestion of ones that, to me, I can understand their immediate application in Canadian law in a meaningful way, not in a rhetorical way, but in a meaningful way that is respectful of reconciliation and respectful of a truthful dialogue. States shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, informed consent before adopting or implementing legislative or administrative measures that may affect them. Now, it's not clear whether they mean the people or the institutions. If they mean the people, that's going to be a problem on its face. If they mean the institutions, that becomes a more recognizable principle that can find a place in Canada. Excuse me. If we could turn to the next slide, please. Now, Article 29.2, states shall take effective measures to ensure that no storage or disposal of hazardous materials, undefined, shall take place in the lands or territories of Indigenous peoples. And let me stop there. That's undefined. UNDRIP does not define. The only definition we have in UNDRIP is the definition I showed you earlier of the lands that were once held by or used by and that are currently held by, i.e. most of Canada. States shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions to obtain their free, prior, informed consent prior to the approval of any project affecting their lands or territories. And again, their lands or territories are undefined. The only definition we have is the definition I mentioned earlier. These are important things. If one is going to say you're going to fully implement UNDRIP, you hit 29 and 32 and you start having some questions about, well, what would that mean to be meaningful? And then this is really a key bullet. Efforts to implement UNDRIP have not distinguished between articles that appear more reasonable and that have an element of functionality in Canadian society with existing Canadian law, and articles that appear on their face to be, I would say, less reasonable, or I will go so far as to say unimplementable. And I've mentioned Article 26 earlier, that in my view cannot be implemented at law in Canada, and I'll suggest you no nation state on the globe will be able to implement it as it is currently drafted. And again, I say that with respect to UNDRIP. Let's jump now to some attempts to legislate. Very quickly, some of you will know about Bill C-262. In April of 2016, MP Romeo Saganish introduced Bill 262, federal, an act to ensure the laws of Canada are in harmony with UNDRIP. And let's be very clear. How could anyone argue against trying to make Canada more harmonious with the general principles of UNDRIP? I want to be clear. That, as a general proposition, is not offensive. But the devil is in the detail. So that's what it says. 262 passed the House of Commons, but it died in the Senate. And it was the first, albeit unsuccessful, effort to implement UNDRIP. Very quickly on 262. I'll be very brief. Just the next slide, please. Section 2.2. Nothing in this act is to be construed as delaying, and I'm going to say this slowly, because what I'm going to try to draw your attention to is what people say this legislation has said and what it actually says. Nothing in this act is to be construed, and this is a direct quote, as delaying the application of UNDRIP to Canadian law. I will ask the rhetorical question, what does that mean? I'm sure some of you may ask me that later. I don't have an easy answer for you. I don't know what it means to say that UNDRIP now applies to Canadian law. Section 4. The Government of Canada, in consultation and cooperation, I'll come back to that later, with Indigenous peoples, must take all measures necessary. Not reasonably necessary and not some measures. All measures necessary to ensure that the laws of Canada, under the Federal Interpretation Act, that means all laws, all regulations, are consistent with all 74 paragraphs of UNDRIP. Let me stop there and tell you that I do not believe that is possible at law. Cannot be done. It's not about whether you want it to be done. It can't be done without having a perverse interpretation of what those plain words mean in UNDRIP. Section 5. Government of Canada will develop and implement a national action plan. Anyway, it died. Let's jump over to British Columbia. The so-called DRIPA, the Declaration on the Rights of Indigenous Peoples Act, passed by the BC legislature in November of 2019. And this was to implement UNDRIP. If we could go to the next slide, please. DRIPA's purposes are to affirm the application of UNDRIP to BC law. Let's stop there. What does that mean? What does it mean when someone says, it's now law, by the way, this is standing law in British Columbia. What does it mean to say you will affirm the application of all 74 paragraphs to every BC law and regulation? I don't know. Contribute to the implementation of UNDRIP and support the affirmation and develop relationships with Indigenous governing bodies, which again, I would suggest nobody would disagree with that as a proper purpose of any legislation. DRIPA requires the BC government to ensure that all BC laws are consistent with UNDRIP. And then it talks about putting agreements in place in an action plan. Let me take you to DRIPA itself. Let's go to the next slide. Section 1.2, direct quote. For the purposes of implementing this act, the government must consider the diversity of Indigenous peoples in British Columbia, particularly the distinct languages, cultures, customs, practices, rights, legal traditions, institutions, governance structures, relationships to territories, and knowledge systems. Now, there are more than 200 distinct First Nations and the Métis in British Columbia. There are 74 distinct paragraphs of UNDRIP. There's every single BC law and regulation. And somehow, the government is expected to implement UNDRIP and must consider the diversity of all 200 plus First Nations and the Métis. Again, I think my point speaks for itself as to whether that provision means anything at law. DRIPA does not contemplate or explain how the BC government will adapt when conflicts between the diverse Indigenous groups inevitably arise. There was a public statement made by BC about, well, look, the sky's not falling in British Columbia. Some of you may have heard this. The sky's not falling. Well, it depends on how you define the sky falling. First of all, the act was just put into law. It's only been about a year and a half, 2 years. Two, I think putting an act in place that on its face is challenging to get your head around about how it could possibly be implemented, whether people describe that as the sky is falling, I would like to think that is not the standard of care when dealing with the relationship that the Crown has with Indigenous peoples in Canada. That ought not to be the standard of, well, the sky's not falling, so it should be okay. I would like to think that our country is sophisticated enough, certainly Indigenous peoples in this country are sophisticated enough to understand the nuances that's involved in what we're talking about. Let's turn to Section 1.4. Nothing in this act is to be construed as delaying the application of UNDRIP to the laws of British Columbia. So some of you have heard from the government, well, this is really a process piece of legislation, right? You've heard some, I know you've heard some of this. It's about process. That's not what this says. These are not my words. This is what the Act says. Nothing in the Act is to delay the application of UNDRIP to every single law and regulation of British Columbia. It lacks specific, nuanced, flexible language that is real, that contemplates the nuances of Canadian law and the reality of Indigenous peoples, particularly in British Columbia. Take a look at let's keep moving. I'm mindful of the time. Section 2 talks about the purposes. I won't go through that again. Let's go to Section 3. This is important, Section 3. And I'm almost done, by the way. I'll go to the new federal legislation. I'll be very brief on that and I'll make some concluding remarks. Section 3. This is a verbatim quote. In consultation and cooperation with the Indigenous peoples in British Columbia, the government, and you'll recognize this language from 262, must take all measures necessary to ensure the laws of British Columbia are consistent with UNDRIP. Now I want to stop there. There is nothing in this about saying, well, it'll depend on how this process works out. This is what, there is an interpretation floating around with, well, look, we've got to work this out with the Indigenous peoples in British Columbia, the First Nations and the Métis. The Act doesn't say that. Parts of the Act say that. Section 3 is very clear on its face. BC must take, and what was the interpretive clause? Nothing should prevent the application from a time perspective. So there's a notion of, well, we've got a decade to sort things out. I would say that the Act says quite the opposite. DRIPA imposes a very high and broad standard of all measures necessary without establishing any reasonable limits on these measures. It lacks specificity, flexibility, and nuance. It's interesting that the Act, like 262, also says consultation and cooperation. I provide you the Oxford English Dictionary, Canadian Oxford English Dictionary of Cooperation, working together to the same end. There are 200 plus First Nations in British Columbia, all of them distinct, with very proud cultures and traditions. So as you start thinking of this as a mathematical equation, remember the early interpretive clause about language, and culture, and institutions of government, combined with 200 plus distinct governments, combined with every single BC law, combined with 74 paragraphs in UNDRIP. And yet the expectation is that all BC laws must be consistent with UNDRIP. That is why I say it cannot be achieved. It's an impossible standard. And in my view, does not serve the interests of reconciliation because of that. The next slide, please. And I've touched on this a little bit, but the government must prepare and implement an action plan to achieve the objectives of UNDRIP. And look, again, I'm not against UNDRIP. I'm not against governments creating action plans to try to achieve as many of the purposes or objectives of UNDRIP. But that's not what it says. It says to achieve the objectives of UNDRIP. Well, I've got news for all of you. UNDRIP doesn't have any objectives. The word objectives is nowhere to be found in UNDRIP. So then you ask the question, well, gee, I wonder what the legislation's referring to. And the short answer is I don't know. My own view is, having been a student of this for my entire career, is that Indigenous peoples deserve much better than this. Reconciliation deserves much better than this. We should be able to say with precision the kind of objectives that we are trying to achieve to get to a better place in our country. UNDRIP does not contain any express objectives. It doesn't contain any aims, goals, or intentions. And most of its articles and preambular statements are deliberately blunt and broad. And when I say deliberately, it's an international document that's trying to deal with countries that send the military in to this day to deal with Indigenous peoples. So it needed to be, and this isn't me criticizing the language of UNDRIP, to apply globally. No other state has Canada's legal regime. So to compare whether it's Peru or other states to Canada would equally be unfair. Finally, and this is a critical point, grabbing one of those books that was mentioned that I did. This book represents less than half of those 70 plus decisions from the Supreme Court of Canada. on that one sentence in 35. This book runs 1,700 pages. Less than half of the decisions. UNDRIP uses language that is completely inconsistent with this from the highest court of Canada. So this notion that somehow we're going to take this instrument that uses completely different language than what Canada has developed, rightly or wrongly, without any explanation of how this is all going to work, I think is suspect. And that's probably putting it mildly. Now, the next section, please. The next slide, excuse me. So remember I mentioned Article 26. Indigenous people have the rights to lands, territories, resources which they have traditionally owned, occupied, or otherwise used or acquired. My interpretation of that is that that's most, if not all, of Canada. I don't think that's an overstatement. Article 26 doesn't take into account the different interests, legislative regimes, protections that apply to lands, territories, and resources. Doesn't acknowledge that we have settled treaties in this country, whether they're historic or modern. Doesn't acknowledge that we have a concept of Aboriginal title and fee simple land ownership. Lands, territories, and resources are not defined in UNDRIP. This proposition in Article 26 is fundamentally incompatible with existing Canadian law relating to Aboriginal title, relating to treaty rights, Section 35 generally, and the notion of Canadian sovereignty. Let's turn to the next section, the next slide. States shall cooperate and consult in good faith in order to obtain their free, prior, and informed consent before adopting any legislative or administrative measures that may affect them. The use of the phrase may affect them rather than that may affect their rights and interests. Think about this. So Canadian law has been built up around either potential rights or proven rights. Article 26 is about things that affect the people. I'm going to suggest to you that that may be every single law. Now, some may argue with me and say, well, it's not every single law. There's some laws that may not affect an Indigenous person in Canada. I acknowledge that that potential exists. But I would say that those laws will be the exception, not the rule. So how are we going to implement this? Really? Really? We're going to seek the consent on every law that may affect an Indigenous person in Canada? Of course we're not. And of course I say that with respect to all Indigenous peoples, but you couldn't function as a country as opposed to affect their rights and interests. The principle of FPIC implies a decision-making right to either permit, agree to a modified version, or withhold consent. Now, some of you have heard, well, listen, this word consent, people are reacting to, it really means consultation. Some of you may have heard some of this. What I just read in that second bullet, that's from the United Nations. The people who drafted UNDRIP were very sophisticated. They understood the language they were using. And when they said the word consent, they meant consent. And it begs the question, well, what if consent isn't provided? Does it mean nothing happens? That is not what the intent of FPIC was. Otherwise, it would have been meaningless. The principle of FPIC on its face goes well beyond Section 35 in the body of case law, if you actually give it substantive meaning. Now, if you give it rhetorical treatment, well, yeah, and I'm not going to deal in that kind of language. Consent means consent. And the UN knew exactly what it was doing. And all you have to do is read their business guide. They're very articulate. And I've given you essentially a verbatim quote from the business guide on that. And of course, we know consent exists with Aboriginal title. Now, turn to the next slide. I want to give you, so remember the sky isn't falling in British Columbia? If you go to their public website, here's British Columbia's definition. So I've given you what the UN has said it means. Now here's the government of BC's interpretation of FPIC. Free, prior, informed consent recognizes Indigenous peoples' rights, interests, and voices. It means early, deep, and meaningful involvement of Indigenous peoples on matters that affect their peoples, communities, and territories. So I apologize if I'm being a bit colloquial, but really? Really? That's the definition? A free, prior, informed consent? Obviously, on its face, it's not a correct definition of FPIC. That is not what FPIC, that is more akin to the duty to consult. The definition mischaracterizes the principle of FPIC and in implying that it's similar to consultation. These are distinct concepts, and the UN recognizes this, and I would suggest to you that the vast majority of Canadians, you don't need to be a lawyer to go, gee, is there a difference between consulting with someone and seeking their consent? You'll see behind me the Oxford English Dictionary. I mean, this is not rocket science. Of course there's a distinction between the terms. And of course the sophisticated Indigenous drafters of UNDRIP knew that. And it's a discredit to the people who work so hard on UNDRIP to suggest, well, somehow these things are all really the same. And you'll see I've provided dictionary definitions. Consultation, the act of seeking information or advice from someone. Consent, the expression of willingness, permission, agreement, compliance. Why do I show you the difference? The difference between what it says and what people say it says, and the gap. And my proposition to you today, to all people that are listening to me today, is that that does not serve reconciliation well. We deserve much better. We deserve to have an honest dialogue about what we're doing. Let me conclude by jumping into Bill C-15. If it's okay, Mr. Chair, then I'll conclude. So in September 2020, Canada announced its commitment to introduce federal legislation to implement UNDRIP. The Government of Canada, here's a quote from the throne speech, will move forward to introduce legislation to implement UNDRIP. I want to be very clear. I am not against attempts to try to make UNDRIP meaningful in Canadian law. So, okay, I've been very clear about this. I'm not against that. What I am against is overshooting the runway, saying one thing, yet doing another, because that fundamentally goes against reconciliation, which requires, first and foremost, truth. So, in December, Canada introduced Bill C-15, an act respecting UNDRIP. In the House of Commons, it's gone through second reading. I'll get to that in a minute. Section 2.3, the next slide, please. You'll recognize this language. Nothing in this act is to be construed as delaying the application of UNDRIP in Canadian law. The purpose of the act is to affirm UNDRIP as a universal international human rights instrument with application in Canadian law. Of course, Canada can't enforce compliance with international instruments that are beyond areas of its jurisdiction. For example, areas that encroach upon provincial jurisdiction. Government of Canada must, in consultation and cooperation with Indigenous peoples, remember this is similar to BC, take all measures necessary to ensure that the laws of Canada are consistent with UNDRIP. And the Minister must, in consultation and cooperation, prepare and implement an action plan to achieve the objectives of UNDRIP. So now we're not talking about 200 First Nations in BC, we're talking over 600 treaty and non-treaty First Nations across Canada, plus the Inuit, plus Métis. Next slide, please. Bill C-15 will proceed through Canada's legislative process. It may be amended. Bill C-15 is currently at second reading of the House of Commons. And I think you've heard me before already state this. It's uncertain how these laws can be fully implemented based on what they say, as opposed to what people say they say. And how all measures necessary can be implemented into Canadian law. Let me conclude. And I appreciate your patience, Mr. Chair, and your committee. Reconciliation and UNDRIP. I want to be very clear that it is important to recognize the efforts to implement UNDRIP in Canada and to support that work. So I want to be very, very clear about this. It is so easy today, people love sort of putting things into boxes. Someone's either against something or for something. I am a strong proponent, maybe I've been practicing too long, that you can chew gum and walk at the same time. You can be in favor of truthful, honest, respectful dialogue with the Indigenous peoples of this country and not overpromise things that everyone on their face knows is an overpromise. UNDRIP, if you look at what BC has said, UNDRIP will form the foundation for the province's work on reconciliation, mandating government to bring provincial laws and policies into harmony with UNDRIP. And Canada said a similar thing, really putting a lot of emphasis on UNDRIP. And I would say not recognizing a lot of the good work that's been done to date between Indigenous peoples and governments across this country, including in the territories, I might add. Reconciliation flows from the constitutionally protected rights of Aboriginal peoples and is tied to the honour of the Crown. This is fundamental law in Canada. If you turn to the next page, please, or the next slide. Some of you may be aware that I wrote an independent report on Métis rights to the Government of Canada going on 5 years ago now as a nonpartisan independent advisor. And in that I talked about reconciliation and my reading of, and again, this is working with so many Indigenous peoples across Canada and their own frustrations, but also what the court has said, that reconciliation is more than platitudes and recognition. It has to be grounded in practical actions, things that mean something, that will change people's lives. And for people, it will look different. It cannot be rhetoric. And for some people, it may be clean drinking water. For others, it may be access to good health care, as every Canadian should be entitled to. For others, it may be having their rights respected. But it can't be just words. Next slide, please. UNDRIP was designed to be a global benchmark. And to be clear, I think it's done a good job at that. So remember, I started my presentation to you today saying I'm not against UNDRIP. And I'm not against attempts at applying it in Canadian law. What I am very concerned about is making promises we cannot keep. And all of us, Indigenous or non-Indigenous, should run away from that. UNDRIP is not a specific legal instrument that was designed to be implemented as law. It just isn't. There will be incompatibilities that can only be addressed by specific, nuanced, and flexible pieces of legislation. Thanks to the efforts of Indigenous leaders, lawyers, and the courts, Canada has the most sophisticated legal regime in the world for protecting Indigenous rights. We're not perfect. We can learn from UNDRIP. We can take the good from UNDRIP. But any discussion of reconciliation in the context of UNDRIP demands truthful, thoughtful, and honorable dialogue and action. And that, Mr. Chair, those, Mr. Chair, are my submissions to the committee.
Thank you, Mr. Isaac, for your presentation. I'll now turn it over to members of the committee for any questions or comments. We'll use the usual format of one question and one follow-up to make sure everyone has time and try and wrap up by 3:40 here. Does anyone have any questions or comments? I will start with MLA Wozniak. Go ahead.
Thanks, Mr. Chair. Mindful of my two-question limit, I'm going to try to skip ahead a little bit. So I guess I have a question around understanding the goals that we are all trying to achieve. And I agree with your goal with what you say in that this is a global benchmark, that we have a sophisticated legal regime, that we have in some ways a very advanced legal regime in terms of recognizing Indigenous rights. And yet, when we say it's impossible to implement it because it would require a fundamental shift in our starting point, I think that's actually the very thing that many Indigenous activists would want, is us to actually recognize that the fundamental starting point is one that is built on colonialization. So knowing that there are maybe voices that would want to, in fact, change the entire starting point, I do look to the legal regime and I say, okay, we have the thick case law that you've presented, the many, many cases that have gone to the Supreme Court of Canada, many of which were not successful for Indigenous rights proponents, many of which were not successful for those claiming or seeking to assert land rights or Indigenous rights. So when we talk about the application of UNDRIP, if we acknowledge that UNDRIP is not legally binding, that it is aspirational, and that it contains a vision of what might be, is it possible that saying that we are going to apply UNDRIP to our laws, that we're essentially giving direction of how to interpret the laws, how to advance our understanding, so that when an Indigenous proponent might come forward claiming a right or access to land, that UNDRIP provides a scheme or a direction by which the Supreme Court of Canada might be able to better understand those rights that they are seeking. I hope that's clear. I tried to pack a lot in.
Thank you, Emily Wozniak. Mr. Isaac?
Thank you. Thank you for the very good question. So I want to be clear. I agree with much of what you said, actually, in your question about as a starting point, maybe changing the paradigm. My point is that the legislation that's been enacted and that's being proposed doesn't do that. What it says is, and this is my point, is that broader aspirational comments that you made, I think the majority of Canadians, in one form or another, people may debate the exact word, but would agree that we should be open to a paradigm shift. But that's different than saying every single federal law, or territorial law, or provincial law will be consistent with UNDRIP, when we know that's impossible. That's what I mean by impossible. I'm saying my position is it can't be done. It's not about whether you want it to be done. You can't do it because of UNDRIP and the way it's drafted. And that's not a fault of UNDRIP. What I don't understand is why the legislation has been drafted that way. Because it's set up that it's, there's going to be legal challenges. And I think I've taken you to the provisions. I think they're very clear what they say. I don't think one needs to be legally trained to understand what the provisions are getting at. They're very, very clear, and they can't be implemented. So I then go back to the starting proposition. If they're really trying to talk about a paradigm shift, let's talk about that. Put that in the legislation. So I guess I sort of, what am I trying to say? I'm saying I agree with your question. And I hope that's helpful. My response is that I think your point's a very good one. My point about the impossibility is not around the paradigm shift. It's about the language of this legislation is such that it cannot achieve what it's saying. Can't achieve. Not that it doesn't want to. It can't do it. So why are we saying it? Doesn't that undermine the very thing we're trying to do? And I have a very strong, as you can probably tell, but I have a very strong view about it. I think that our country is sophisticated enough. I think we're all smart enough to have a nuanced, flexible understanding of these things and pick the good out. So that if that is the issue around a paradigm shift, let's talk about that in the legislation. And I would think that most Canadians are willing to have that discussion. Maybe not every last one of them, but certainly a lot of the ones I know are willing to have that discussion and think it would be a good thing. I hope that's helpful.
Thank you, Mr. Isaac. Emily Wozniak?
Thank you, Chair, and that is helpful. It actually does, it then leads me to another question, which would be, if the issue is around when, as British Columbia and the federal government are trying to craft legislation in keeping with the spirit, shall we say at least, of what is being asked for, which is some form of paradigm shift. Is it the language that's being used that is problematic? And I think it is from what you've said already over the course of the presentation and in that response. And so that rather than saying something like being consistent with, is it the language of being consistent with that creates the impossibility? And could we not find alternative language that speaks to the idea of vision and value so that it's not impossible?
Mr. Isaac?
Thank you, Mr. Chair. I completely agree. I think you're absolutely correct. I think that would be a healthy dialogue. The language of consistent with, and how about take all measures necessary? No. Governments will not be taking all measures necessary. We know that now. I'll say that now. Governments can't take all measures necessary because it would require them to change, I'm going to suggest to you, probably every law in the books or almost every law. And in fundamental, radical ways, if the words are to mean something. Now, if the words are not to mean something, then why do we put them in the legislation? If it's more about the spirit of UNDRIP, if it's more about the paradigm shift, if it's about taking the really helpful out of UNDRIP. So, for example, I comment a lot about some of the rights, and I didn't go through them with you today because of the time, dealing with education, health, social programs, the right to a clean environment. Now, there, UNDRIP, I think, could be extremely valuable to Canada. I actually think that would be a very useful use of the language in UNDRIP. But as it's drafted in the BC legislation and the proposed federal legislation, it cannot be implemented. So it begs the question, why are we setting a legal standard that cannot on its face be met?
Thank you, Mr. Isaac. Is there any more questions or comments from committee members? MLA Simpson.
Thank you, Mr. Chair, and I really appreciate the presentation, and I hope that the members of the public are watching this as well. I think it was very, very informative. We hear a lot about UNDRIP, and I think from a lot of people who've never read UNDRIP and who don't understand some of the implications. You know, as legislators, we agonize over single words in our legislation, and to try and incorporate this document that was never intended to be legislation into that framework is it's an impossibility, as you're saying. And once you start doing that, once you start setting this mark that you can't hit, and you accept the failure, well, then why bother trying to succeed on any of those, right? So I agree. We need things we can accomplish. And as you stated, that Canada is, among the world leaders in terms of protecting Indigenous rights and reconciliation. And obviously, it's not perfect. And I would say in the territory, we're leaders in Canada, although obviously it's not perfect. And so when I ask this, I know that maybe the examples are here, but do you have examples from perhaps other jurisdictions of UNDRIP being implemented in a way that has been successful? Yeah, I'll leave it at that. Thank you.
Thank you. Mr. Isaac?
Thank you, Mr. Chair. No, I don't have what I would call material examples of actual implementation of and I won't say every single provision of UNDRIP, but most of UNDRIP. No, I'm not aware. It doesn't mean they don't exist. It's possible. I'm not aware of every example, but even the ones where you find UNDRIP fully implemented in law, understand it does not fetter the state. So Canada's constitution, so there's some examples, and I won't get into the countries, but where they'll say, well, it's in the Constitution. Well, before we take that, find out what they need to do to amend their Constitution. I'm talking about some of the Central American and South American states. And again, I'm not trying to be critical of them. But again, we have to go beyond the rhetoric and really do a deep dive. My point, in terms of the member's question, I mean, my point is that, I've spent my career, and I earned my living, quite frankly, dealing with broken promises. I mean, I'm on some files that are very optimistic and forward-looking. And we have a very large practice. I'm active in every jurisdiction of Canada, so I work in every province, every territory. And most of my week is dealing with broken promises, and usually from governments. And again, I'm nonpartisan. I feel strongly. I'm a big supporter of our country, and I'm a big fan of Canada. We have a great country. But our legacy is one of broken promises, and it's generated a lot of work for me in my career. And that is the reaction. That's where this is coming from. that when we put something in that we know, any reasonable person looking at those provisions, whether you're a lawyer or not, knows you can't align every law with UNDRIP. And I've got news for everyone. Everybody knows that. So why are we doing it? And for me, I feel very strongly that it's disingenuous in terms of, I think, the sophistication that where we're at as a country, that I think we should be striving for higher than that. And we should be trying for the nuance and being proud of what we've done as a country to date, and also being aware of all the things that we are failing at. And we've got a lot more work to do. And again, I'm being very clear about this. But this notion that someone, we'll just adopt UNDRIP and that'll be the next thing. I think we're beyond that as a country. I would like to think that we've reached a level of sophistication in this country that this isn't the latest monorail project that's coming along that we're all going to say is going to take Canada to the next level. I think we're beyond that as a country, and I think that we deserve more than that, whether you're Indigenous or non-Indigenous, and especially given the level of sophistication. Again, I have the honor of working in every jurisdiction, and I mean, the country's ready for a sophisticated discussion on these issues. So that's my comment.
Thank you, Mr. Isaac. Any follow-up, MLA Simpson?
No, thank you very much. And I think that we can achieve, there's things that we can achieve, and we don't need to be, or how would I put it like this? To many people, I think you sort of alluded to this, implementing UNDRIP seems like the end as opposed to a means to an end. It's something, look, we've implemented UNDRIP. We have this legislation, we're done. No, there's a lot of hard work that needs to be done, and I think that we can focus on doing that hard work and getting to where the spirit of UNDRIP is leading people. So that I get just a comment, Mr. Chair. Thank you very much.
Yeah, thank you for that, MLA Simpson. Agreed. I'm going to go to those on the phone. MLA Semler or MLA Martselos, do you have any question or comment? Or Madam Premier?
Yeah, I have MLA. This is MLA Martselos.
Go ahead, MLA Martselos.
That was Mr. Isaac. That was an inspirational presentation. And I've been I was chief before I became an MLA for 13 years, and have a lot of background on this. And what you said was honest and sincere, and I appreciate that. So we could use the guidelines, but in the Northwest Territories, the majority of people are of Aboriginal descent, and we could do something along the guidelines, but something amazing and inspirational to address these whole issues. And I think in future laws that we do in the government, we have to be mindful of that. But wasting our time on UNDRIP, it sounds good, but I feel that why waste our time on a document that is never going to be implemented anyways. The territories, because of the majority of people being Aboriginal, and we only have, I think we have 31, or I think First Nation, and the rest are a couple of Métis nations. And my question to you is, under Section 35, this is one of the biggest arguments we've always had in discussions with the Métis and with treaty rights. The government of Canada seems to have put them both together now. And a lot of the people with treaty rights, like myself, although I represent Métis people and I do it equally, is there a difference in the way that they've described the Section 35 now? And the Liberal government seem to have gone that way. And I just want to see if you see that distinction the way I see it, or tell me how it should be. Thank you. Thank you, Mr. Chair.
Thank you, MLA Martselos. Mr. Isaac?
Thank you very much for that question. Thank you, Mr. Chair. So, at law, First Nations, Inuit, and Métis rights are equally protected under Section 35. That is the case law to date in Canada. It is very clear, in my view. Having said that, and one of the things that I emphasized in my report is that just as so many First Nations are they're distinct nations. Likewise, the Métis are distinct. And their rights may manifest themselves differently, just as they do differently for First Nations or the Inuit. But certainly with First Nations, I mean, when I look at how rights are framed, for example, on the East Coast, I do a lot of work in the Maritime provinces, very different than what we see in Ontario. And yet again, very different than in British Columbia. And yet again, very different, for example, where you are in the Northwest Territories. And so I would certainly be the last person to sort of lump, well, first of all, I think it's disrespectful to lump all of our Indigenous peoples together. And I work with so many First Nations who, I mean, even just saying First Nations and not acknowledging the distinctness of each of those nations, I know can be a very sensitive issue. And I try, I'm certainly not perfect, but to try to respect that distinctiveness. But certainly the same distinctiveness applies to the Métis. And even even among the Métis, I mean, if you go to Ontario and talk about some of the history there versus Manitoba, versus the Northwest Territories, for example, versus Alberta, you will get very different stories. And certainly my view, and I believe Canadian law, so I'm answering as a lawyer, I believe Canadian law acknowledges that distinctiveness. So I hope that at least addresses in part your question.
Thank you, Mr. Isaac. MLA Martselos, any follow-up?
No, Mr. Chair, he answered my question, and he said they were all equal under Section 35, and that's all I wanted to make sure that was clear. Because we go to these assemblies, and many times people will bring these kind of issues up, and I think without legal opinions. And so now, as legislators, the MLAs of the government of the Northwest Territories must realize under Section 35, everybody is equal with the Indigenous rights. And I just wanted to make that I wanted to make sure that I heard that very clear. And I knew that was clear because I've had a strong Aboriginal lawyer from Alberta that represented Salt River for 12 or 13 years, and she's still a friend of mine. So I just wanted to make sure that's clear, and I want to thank Mr. Isaac for his answer and excellent presentation. Opened my eyes completely, especially to deal with UNDRIP, and it's a nice document to look at, but it's not going to work. We can't waste our time trying to implement all these things when it's not going to happen. And and I see that now, and I'm a very strong advocate for Indigenous people in the North in the Assembly. But I know that wasting our time on a document that is not going to happen is not okay. Thank you so much, Mr. Chair.
Thank you, MLA Martselos. I see MLA Semler has turned her question on. Do you have a question, MLA Semler?
Thank you, Mr. Chair. Not so much a question, just more of a comment. First, I'd like to thank Mr. Isaac for his presentation. It was a very thorough, helped me understand some of the different areas and some of the challenges, as this is we're just starting, and it's our beginning of our presentations on this topic. I will take all the information and be able to, I think, better understand where we're going, and if we're going to be able to, like you said, will we be able to do this with legislation in Canada and even within the Northwest Territories, it's going to be difficult. And I'm glad this was a public presentation because it shows public how it's not just a flip the switch, turn it on, and we've got it done. So it's going to take a lot of work, and it's going to take a lot of different partners. It's going to take more than just government, to try and make this change. So thank you again for your presentation.
Thank you, Emily Semler. Yeah, and I think the whole committee is thankful for what is our first of many presentations on this topic. Next, I have MLA O'Reilly.
Thanks, Mr. Chair, and thanks for the presentation. I guess I'm trying to read between the lines a little bit here. Certainly the Saguenish bill, the BC legislation, and the new federal act all have some shortcomings if we interpret them quite literally. Is it your suggestion or recommendation then that we don't try a legislative approach to implementing UNDRIP, or would we better serve by, trying to change other aspects of the way that we make decisions around lands, resources, our judicial system to better implement reconciliation and UNDRIP? Thanks, Mr. Chair.
Thank you, MLA O'Reilly. Mr. Isaac?
Yes, and thank you, Mr. Chair. So thank you very much. It's a very good question. My first comment would be that certainly as counsel, I will read things literally. So I will read it on its face. And I would think with respect to reconciliation, and again, this is a key part of my message, that we must read it on its face. And it should be crystal clear. There shouldn't be ambiguity in something so critical to all Canadians, whether you're Indigenous or non. We have to get these things right. We've got enough wrong in this area. We need to get some things right. So that's my first point. My second point is that we haven't implemented Section 35 yet, let alone UNDRIP. You have to understand, I earn my living. My day job is acting for governments and industry for the most part. I do now act for some Indigenous peoples, and I'm very proud to do that. But there was a decision back in the mid-90s that told provincial governments, and I'd say it's applicable to the federal government and territorial governments, go through your legislation, and where you have a minister exercising discretionary ministerial authority that may affect an Aboriginal treaty right, give direction to that minister to ensure that they take into account Aboriginal treaty rights. I am only aware of 2 examples of regulations that have ever been changed in Canada based on that express direction. Now, I'm sure that there are other examples, but my point being, we have got legislative regimes across the country, and again, I say this with respect to public governments, that are wanting and are impoverished in terms of their approach to implementing Section 35. So now what we're going to do is go, okay, we'll get to that someday, but now we're going to implement UNDRIP, which is completely foreign to us at law in Canada, and somehow we're going to completely implement all 74 paragraphs of UNDRIP. So that is, I believe that is an answer to the question. That one final comment is that I do think, and I'm actually working with a public government client right now to look at some form of legislative response that doesn't make promises that can't be kept, that is respectful of the First Nations. In this instance, it's only First Nations that are at issue, that respects the First Nations, and that is meaningful, that can be implemented. that resources can be put to in a discrete, focused way, and will hopefully make lives better for people. We're looking at trying to do something along those lines. I think it can be done. And again, my caution today is overshooting the runway, because I don't believe that. Ultimately, over the long term, over the short term, look, you know, again, you folks are the experts. I'm not the experts on this over the short term in terms of what it may mean. But over the long term, it is unsustainable because it can't be implemented. So then you go, well, where does this ultimately go? Is it a reneging of the legislation? Is it a redrafting of it? Is it government arguing against its own legislation as to what it may mean? And that would be, I think, terrible. That doesn't help move us forward as a country. So I do think that there are legislative options available, but they aren't necessarily the drafting that I see in the examples that I gave you today.
Thank you, Mr. Isaac. Going once more to committee, are there any questions or comments? Madam Premier, the line is yours. I believe you're muted. We still are unable to hear you, Madam Premier.
Oh, no.
Unfortunately, we missed that one. I'll go once more to committee and give, if you can try and unmute yourself, just interrupt me. Are there any other questions or comments? MLA Cleveland.
Thank you very much, Mr. Chair. I appreciate, and first of all, thank you for the presentation. I appreciate what was said about broken promises and not wanting to enter into any more broken promises. I definitely believe that a lot of, that this document was born out of a need because of a lot of, or a legacy of broken promises throughout the history of Canada. And when I look at, you know, why I feel personally that the United Nations Declaration of the Rights of Indigenous Peoples is important, I look at education, healthcare, housing, and I look at the people that this really would affect and have positive in their lives if on the face of it, it was implemented. And so what I'm looking for then really is that whole theory around the paradigm shift within the system that created broken promises and created a need for the United Nations Declaration on the Rights of Indigenous People. And so I guess what I'm asking is in the spirit of needing a paradigm shift, where do you suggest that governments like the government of the Northwest Territories start in order to create that paradigm shift?
Mr. Isaac?
Well, I want to thank you, Mr. Chair, and I would like to thank the member for that excellent question. That is a topic I don't get to talk a lot about. I mean, I'm a lawyer. I do negotiations and stuff like that. I'm in court sometimes, but I don't usually get asked a question about, I mean, I interpret the question as how do we affect people's lives in a meaningful way? So I'm sitting right now in West Vancouver. I live in a very lovely neighborhood here. Just this way and I won't get into the names of the communities, but over the mountains, some of the poorest communities I've ever seen. And I've had the honor of visiting communities across the country. There's something fundamentally offensive that we can have Canadians, Indigenous Canadians, that are living in less than standard houses, without clean drinking water, 50 clicks away from one of the great metropolis areas on the continent. There's something fundamentally offensive about that. And it costs Canadians, whether you're Indigenous or non-Indigenous, a lot by not allowing all of us to rise. You know, as the boat rises, all of us should rise. So your question, remember, I think really hits the nail on the head, to be quite honest with you, and I completely agree with you. UNDRIP is important. And you know, your point about education, health, and so on, I couldn't agree more with you. And my personal view, but again, I think this is really up to public governments, democratically elected leaders, and Indigenous leaders, not people like me in the bubble, but I do have a view on it. And my view is that more attention needs to be paid to helping people be their better selves, and to supporting people, to getting people out of squalor, to making sure that every Canadian has reasonable access to a decent education, decent health care, and just because they were born on a reserve. And I mean this very genuinely. You know, Canada has slowly been making progress on dealing with the residential school legacy. And as terrible as that legacy is, we should also be proud that we are trying to deal with it. I feel very strongly about that. And the legacy that that's created and the cost it's created to our society generally. So I hope that answers your question. I have a very strong view that I think all of us will do better. Me here sitting in my house will do better when everyone has access to clean drinking water in a nice, safe house with a nice, clean backyard, or whatever it is you want, whatever makes you happy. But we've got to make sure, and we've got to make sure that we're not picking favorites. This is another thing that, unfortunately, I see across the country, that resources, I understand, are finite, but when it comes to basic human needs, talking about, and again, I make my living on this, but this is important, but there's another piece to the equation. And the other piece of the equation is people getting a decent meal, First Nations kids, Métis kids, Inuit kids getting a fair crack at a decent education, because that will help all of us. So that's, I'm being very honest with you, that would be a great day to see those parts of UNDRIP being picked out and going, something, let's hit a home run on education. Let's hit a home run on clean drinking water for everyone. It doesn't matter where you live or what your ancestral background is. We're going to make sure that you get, and UNDRIP could play a very, very powerful role in that.
Thank you, Mr. Isaac. Any follow-up, MLA Cleveland?
Thank you very much, Mr. Chair. I mean, I guess just in regards to, if we pick one thing, like if you pick housing, there are elements of each and every one of the pieces of our government that are important to the people of the Northwest Territories that have a role to play in UNDRIP. And so my fear and I've listened to your presentation today, and I have a lot, I think, to unpack afterwards. But my fear is that if we remove UNDRIP from the table, then, you had made a comment earlier about taking 10 years to implement it and that being a concern. My concern is that if we don't have a guiding document like this, that tackling things like, people being evicted from their houses and then their kids being removed from them and kids being driven into foster care, there are policies that kind of that don't help us get to where we want to go. And so if we don't have a guiding document, do we ever unpack those items and dissect them for what they truly are? And so I suppose our government needs the drive, the ability, and the plan, I guess, in place in order to be able to unpack each of those items. And so that's my concern with today's presentation. So I guess more of a comment than anything. Thank you.
Mr. Isaac, turn it over to you.
Yes, thank you, Mr. Chair. Just very quickly, I completely agree with the comment around a guiding document. To be very clear, I am not advocating in any way that Canada should ignore UNDRIP or the provinces or territories should ignore UNDRIP. What I am advocating is that we take an honest, transparent approach to UNDRIP that will be meaningful. I thought your language of guiding document was really interesting, and I'm not suggesting I'm drafting anything here today with you, but trying to capture, and earlier questions were getting at this point of the spirit, and even when you look at some of the public statements from the government of British Columbia or the government of Canada, they're capturing what's trying to be done. The problem is that what's been drafted doesn't match with what the objective is. And my proposition to you is draft what you intend, because that will be, and it's okay to set it as an aspirate. It's okay to set the bar high, but don't make it an impossible bar that anyone reading it on its face goes, well, it's essentially meaningless because it can't be done the way it's been drafted. And it's more than just a legal point. It goes to the core of reconciliation, of being truthful, saying what we mean and meaning what we say. And I just happen to have a very strong view. And again, maybe I've been doing this too long and I'm all jaded about it, but I just, at this point with rhetoric, if we want this to be a guiding document, I love that language, then let's say that. That to me would be very positive. And yes, we're going to consider UNDRIP when we look at these things. Yes, it will be given full consideration and putting meaning behind those words about what we mean by that. That could actually achieve a lot of good and open up a broader dialogue. Thank you, Mr. Chair.
And thank you, Mr. Isaac. On behalf of committee, I think your presentation was greatly appreciated, and we as committee are going to have many more conversations. And but out of respect for my colleagues who have to go to other meetings, I'm going to seek a motion to adjourn. But thank you, Mr. Isaac, for presenting today.
Thank you very much, and I appreciated the opportunity to present to you today. Thank you.
Committee, may I have a motion to go in camera? Thank you. Mm-hmm.